All right, good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon, Judge Richardson.
All right. So we are here on the motions in what I will call the Mohawk Industries case. We've got 4 separate cases, 4 separate motions to dismiss. I will confess that I did not completely read all 4 motions to dismiss. I read them and then compared them next to each other and found them all to be substantially similar in their arguments. But, you know, as we go along, I'll ask counsel if there's, if there are any particular facts or legal issues that they want to argue as to a particular case, but I did not see any. So if we're all, we can start with the motion. I believe it's defendants' collective motion in all 4 cases. So whoever's going to take the lead on that, you can go ahead and get started.
Thank you, Your Honor. Robert Long, on behalf of Mohawk and speaking for the defendants today. I wanted to start by asking if we have any particular ways you'd like to go about it, time spent on it. Should we reserve time for rebuttal, or how would you like to handle that today?
I'm, unless you're prepared to go for an hour, I'm not. I don't have any particular time limitation on it, though. I may stop you if I think that it's, if it's going a little bit long, I may ask you to cut to the chase. But other than that, I've got pretty much all afternoon to spend with you fine folks.
Appreciate it. I'm not going to do that to you, Your Honor. It's not going to be an hour, I promise. All right, I'll begin. On behalf of defendants, thank you, Your Honor, for taking the time. I know that the court has papers piled up high on these motions to dismiss, and I know it might seem at first blush like the hedge fund's laundry list of allegations just couldn't be subject to dismissal at the pleading stage. I get that. But the good news is the court does not have to sift through and weigh the hedge fund's allegations to understand why this case should be dismissed. Instead, on close examination, which we'll walk through today, the court can see the claims fail not because of what they have alleged, but because of what they have not alleged. First, the complaints do not and cannot allege a Georgia Securities Act claim. They filed that claim 6 months too late. They do not dispute that, and so they're gone. Second, 3 of the complaints, not the Sorban complaint, but the other 3, do not and cannot allege facts that they relied on any misstatements by the defendants. Third, the complaint do not and cannot allege facts supporting the allegations that the defendants knew of any of the alleged wrongdoing, much less that they intended the alleged wrongdoing. Fourth, the complaints cannot show the wrongdoing caused the stock drop because they do not and cannot allege the public ever heard about the so-called wrongdoing. How could the alleged wrongdoing have caused the shareholders to sell all their stock if they never had even heard of the alleged wrongdoing? It makes no sense. Fifth, the complaints do not and cannot allege the predicate acts for a RICO claim, nor can they allege that there was a RICO conspiracy claim. And finally, and this is just for the value recapture complaint. In the value recapture complaint, they don't have standing. They can't allege harm. They were assigned the rights, and under Georgia law, when you're trying to bring fraud claims that sound in fraud, you don't have standing if you can't allege harm in an assignment. So I'm going to go into these points in more detail, but before I do, I want to give you a little context for these claims. The hedge funds are sophisticated investors. They are managing billions of dollars And they lost money when Mohawk announced disappointing earnings in 2 quarters in 2018, okay? There is no evidence that Mohawk's disappointing earnings were because of improper accounting. There is no evidence that Mohawk has ever been engaged in the scheme alleged in the complaint. They have never filed a financial restatement, and KPMG, their longtime public auditor, has reviewed and signed off on their financials every single quarter without fail. Nevertheless, in hopes of recouping some of their losses, the hedge funds bring this lawsuit trying to get an insurance policy on the losses, offering nothing more than conspiracy theories and innuendo in a matter that, if the hedge funds get past this motion to dismiss, will leave Mohawk facing many millions of dollars in defense costs. That's not right. And we ask the court dismiss the claims under the law. All right, so I'm now going to turn to the details of the allegations. First, the standard. When you're looking at these allegations, Your Honor, Georgia law requires that only those allegations that are well-pled material allegations can go forward. And there are a number of situations where the allegations here fall short. Statute of limitations. Talked about it a little bit. Going to talk about it in more detail now. On the Georgia Securities Act, they blew the statute of limitations. It was 6 months too late. They admit that. Now, what they try to do in an effort to resuscitate those claims is to argue there should be equitable tolling because there was a federal securities class action that was filed in January 2020. And so the statute shouldn't start or stopped then, okay? There's a problem with that though. The securities class action claims are totally different claims than are here. Those are the federal securities laws. They have different standards. The elements are different. The requirements are different. They just are different. Here we've got RICO claims, we've got theft, we've got negligent misrepresentation. They're just different, and they're all Georgia state law claims.
Talk to me about the substantive difference between the common law fraud claim and the Georgia Securities Act fraud claim. If when I look at the statute, it seems to just lay out the elements of fraud statutorily. So what is the substantive difference that would make this an entirely different claim?
Reliance, in a word. The federal securities class action plaintiffs do not have to demonstrate reliance. Under the federal securities laws, for reasons that go back a long time, they do not have to demonstrate that they relied on the statements. The reliance is presumed. Here, in these claims, under Georgia law, the plaintiffs have to demonstrate that they relied on specific misstatements and that they identified the specific misstatements that they relied on. That's a big difference.
All right.
So, like I said, they are totally different claims. And instructive here is the private truck case, where they say the following, quote, the doctrine of equitable tolling protects only those claims asserted in the class action lawsuit from being barred by the applicable statute of limitations. It does not apply to resurrect claims not asserted in the lawsuit that are time barred. So that's a Georgia case.
But isn't that case distinguishable, because that case, well, distinguishable in this respect, isn't it distinguishable in the respect that in that case, the statute of limitations had already expired before the federal class action lawsuit was filed.
Your Honor, I think that the primary point still applies in this case, which is if you filed a class action and you then try to file claims that have expired, then you can't point to the class action and say that class action tolls it.
Does Georgia law speak to cross-jurisdictional tolling? Either
It does not.
against it?
It does not. It has not spoken on cross-jurisdictional holding. I don't think we should create new law here. I think the Tennessee court in Maestas said it best. I hope I'm pronouncing that right. Maestas said it best. We don't want this state to be a clearinghouse for opt-out plaintiffs who don't want to join a securities class or a class action. That doesn't make sense for those. But even if there were going to be the cross-jurisdictional doctrine applied here, again, I'll go back to my initial point. The claims in the federal securities class action are different than the claims here.
So tell me how they're different. Tell me, just give me an example or two as to how the federal claim differs from the state claim.
Well, the main one that I wanted to point to, well, let's just talk about the common law fraud claims and put aside the RICO claims and the theft claims, okay? The common law fraud. What the reason for the reason I point out reliance is what happens is if you're in a securities class action, you're bringing something on behalf of all shareholders. You can't go through, and by the way, plaintiffs here could have joined that class action. Nobody's arguing they couldn't. They could. Because they are a full all shareholders. The Supreme Court has decided, look, we're not going to make you plead reliance. We are going to assume that the whole market relied on any statement that was made to the public by the company or the company's representatives, okay? We're just going to assume that. We can't do class actions any other way. And so that is the doctrine of the federal. This is very different. They have to, like I said, show that they relied on whatever misrepresentations they claim were made. They have to identify what statements this was, and we'll get into this in the reliance portion, and how, and what made them rely on it. So it's just a different claim.
All right.
All right, unless the court has any other further questions on the statute of limitations issues for the Securities Act, I'm going to move on to value recapture's standing problem.
All right.
Okay. They argue, value recapture argues that because they were assigned all the claims, they have standing. That's not Georgia law. Under Georgia law, for claims that sound in fraud, if you're an assignee of claims, you don't have standing because you're not the one who suffered the harm. And you've got to be able to allege harm if you're going to have standing. It makes sense. Now, what they try to argue is they try to argue that they have capacity. That means they have the legal right to do things on behalf of the assignee, okay? Or the assignor, sorry, the assignor. So that's true. They do. They can act on behalf of the assignor. They have capacity, but that's very different than standing. A basic requirement of standing is that they be able to allege harm, and value recapture cannot allege harm here.
If they step in the shoes of the assignor and they are in a different financial position than they otherwise would have been. If someone had breached a contract and they didn't have money available to it that would have if the contract wasn't breached. I'm not sure how in that circumstance, an assignment would affect their standing to sue to recover that. Isn't value recapture alleging some loss of financial position as a result of this alleged fraud?
Well, they can't allege loss because they weren't the ones suffering the loss. And I'd like to point you to OCGA 441224. I'll quote here. A right of action for personal torts, for legal malpractice, or for injuries arising from fraud to the assigner may not be assigned.
Give me that
Yeah.
again.
Yeah, sure. It's 441224. There are other cases. The Patel v. Diplomat case says federal and state courts construing 441224 has held that fraud claims are not assignable. The Pittard case, finding that Merrill Lynch's right of action for injuries arising from fraud could not be assigned. While a judgment based on fraud may be assigned, a right of action for fraud may not. That's the law in Georgia. And all these are in our briefs it's only in the value recapture brief because they're the only ones that lack standing on this basis. That's one distinction between the four briefs. Now, they also argue that plaintiffs, even if we can't bring our fraud claims, we still got the negligent misrepresentation claims, right? Wrong. They don't have those. The problem is the negligent misrepresentation sounds in fraud. It is a species of fraud. And so those claims, they don't have standing for those claims either. That's my argument on standing, and I'll move to the RICO claims unless the court has further questions on the standing claims.
All right, so you have a case that negligent misrepresentation is not an assignable claim?
I do not have a
hear
case.
you on the fraud, but tell me about negligence.
I do not have a case that specifically holds that, Your Honor. But I think we do have cases that note that negligent misrepresentation claims sound in fraud.
All right.
Okay, the RICO claims. The plaintiffs don't allege RICO claims. They don't properly allege them. There have to be two predicate acts for a RICO claim to stand. They can't even prove one. The Securities Act claim we've already talked about. Then the other predicate act that they allege is theft. I mean, I don't know what to do with that. The defendants didn't take the plaintiff's property. There's no allegation that the defendants took the plaintiff's property. When we raised that in our papers, in our opening brief, and demonstrated why they couldn't plead theft, plaintiffs didn't even respond. They abandoned it. And so I think it's clear that they can't plead the two predicate acts for RICO.
Isn't there a mail and wire fraud
There is.
claim in there? Tell me about that.
There is, yes. So mail and wire fraud under Georgia law has to be pled with particularity. And if you look through these complaints, you will see that they never identify which so-called misrepresentations went over the mail or went through the wires. What they generally allege is representations were made through the SEC filings and through the investor conferences, but they don't identify a single misrepresentation that actually went through the SEC filings or the investor calls. Much less do they identify ones that they relied upon or that they reasonably relied upon. So under the more stringent particularity requirements of the mail and wire fraud statutes, they have not appropriately pled that here. Now, the RICO conspiracy claims. You got to have predicate acts. They haven't pled that. We've already talked about that. Besides that, they've never alleged the defendants entered into any sort of agreement to do any sort of wrongdoing. You look through the complaint, they say both Mr. Lorberbaum and Mr. Boykin did wrongful things, but they never allege that they agreed to do them together. That's just not there. And so under Georgia law, a person can be found liable for RICO conspiracy, quote, if they knowingly and willfully join a conspiracy, which itself contains a common plan or purpose to commit two or more predicate acts. That's nowhere in any of the four complaints. Unless the court has any further questions about the RICO claims or the RICO conspiracy claims, I'm now going to move on to the fraud claims.
Okay.
As the court has already noted, the fraud claims have a bunch of elements. I'm going to rest on the papers on some of the elements, and I'm going to only address three. First, reliance, which we've already talked about some, but I'm going to talk about more. Second, scienter. And third, loss causation. Three of the complaints, Corvex, Incline, and value recapture, fail to plead reliance because they don't point to a statement or a mission that the hedge funds actually or justifiably relied. The hedge funds assert that they invested vast sums because of the misrepresentations around LVT. The hedge funds also claim that they would never purchase Mohawk securities at all or at the price they paid if they knew the true facts about Mohawk's alleged schemes. And they relied on the misrepresentations or omissions to remain a holder of Mohawk stock. But those kind of vague allegations are a verbal sleight of the hand. What you don't see is any of the complaints identifying any specific statement that they relied on. For example, the hedge funds assert that they relied on representations concerning Mohawk's LVT production plans, but they don't identify which representations were made or when they were made, or even that they're the same representations that the plaintiffs are now saying were false. They don't even do that. The complaints never allege that the hedge funds relied on any of the alleged misstatements, not the ones about Mohawk's earnings, revenues, margins, capacity constraints, or the certifications that Mr. Lorberbaum and Mr. Boykin signed when they made their public filings. None of those they allege they relied on. Also, under Georgia law, sophisticated investors, hedge funds managing billions of dollars, have to show they reasonably relied on these so-called misrepresentations. They have to demonstrate under Georgia law that they conducted due diligence. They can't just say they heard something about it and so they invested. They don't allege that they performed any sort of analysis of Mohawk's public filings, earnings reports, that they attended any of the investor conferences, or that they sought to speak or actually did speak with company management. Communications made to all shareholders. I've already talked about the federal securities class action. It would be enough in federal claims, but it's not enough under Georgia law. They have to show the specific statements upon which they relied, and they simply don't allege that.
Do they have to show that at the pleading stage? Isn't it enough at the pleading? Well, tell me why it isn't enough at the pleading stage just to allege a number of specific statements and then say, we relied on those to our detriment. And then it goes to discovery on that issue.
Well, Your Honor, I think that first of all, the standard is material allegations, and that means they have to identify the specific statements. And also, I'd like to give you a quote from the Greenwald case. In designating the occasions on which the affirmative misstatements were made, the plaintiffs must identify the specific premise upon which they relied. So there is a requirement under Georgia law of specificity. They have to at least tell us what misrepresentations they supposedly relied on.
But
Otherwise,
if they've identified a numerous specific statements that they say were false. Taking those through, if they say, well, we relied on those statements, tell me why that isn't enough at the pleading stage, at least.
because in this sort of case, there needs to be more to understand what exactly they relied upon.
All right, go on.
Scienter. The complaint has to allege the defendants acted with scienter, which means intent or serious or severe recklessness so significant that it demonstrates intent. All the complaint has in this case is that Mr. Lorberbaum received an email describing LVT production issues, that he attended a single meeting in the summer of 2018 regarding those issues, and that he had reports prepared about, called quarterly sales reports about LVT, which it certainly shouldn't be a surprise that Mr. Lorberbaum attended a meeting, got an email, or reviewed the reports that were provided to him. That is not enough to show severe recklessness or intent to commit wrongdoing. Moreover, the plaintiffs don't explain why Mr. Lorberbaum or Mr. Boykin would actually be motivated for this so-called scheme. They don't say that they personally profited from the fraud. They don't say that they were the beneficiaries of any financial windfall. They just don't give a motive for it. They didn't sell, they're not alleging they sold stock to try and gain an advantage that way.
Well, tell me why that isn't a matter for discovery. If they allege intent, they allege that they know, and their circumstances raised meetings that these two high-ranking individuals would know if there was something materially false going in their public communications. Tell me why intent and motive wouldn't be a matter for discovery.
Because they need to identify, because, Your Honor, first of all, these types of claims need to be carefully considered and questioned on material, on whether the allegations are just conclusory or whether they are material. These kinds of claims cost millions and millions of dollars to defend. And a plaintiff should not be able to say, oh, there was fraud, and then be done with it. I mean, if they had alleged that Boykin and Lorberbaum were aliens with three heads, embodied in humans who were trying to destroy the earth, clearly that would be something where you'd want to kick the tires on that a little bit and ask whether or not it's a credible claim. And all, again, that they've alleged is an email, a meeting, and LVT. They don't talk about what was discussed. They don't talk about the details of it at all. They just say they got some emails and had a meeting. And that's intent. That's not enough.
All right.
Loss causation. This is a big problem for them. They concede that the alleged wrongdoing has never gone to the public. It hasn't. So logically, how could the shareholders have sold off the stock, causing a stock drop, if the shareholders didn't even know about the alleged wrongdoing? They don't have an answer.
But if the wrongdoing causes the drop resulting in loss, isn't that chain of causation, or at least that allegation of a chain of causation, enough?
Well, let's start with the basics. What's not enough? It's not enough to allege that they announced that they weren't going to make earnings and then the stock dropped, because that could be from a number of different reasons, right? And that's all they've got. If they had said that there was, for example, an article that came out identifying something that a reporter had discovered about Mohawk and the stock dropped, then that would be, they would have an argument that it went into the public. But how could the shareholders have sold off their stock because of the wrongdoing if the shareholders didn't even know, had never heard of the alleged wrongdoing? It just doesn't add up. It's not a logical argument to make. If this was something where, even if there had been restatements, financial restatements by the company, or there had been, some investigation that uncovered wrongdoing, or there had been some judgment by some court that they were engaged in any of the wrongdoing that is alleged here, I would say, look, that could be enough to show at the pleading stage that they've got causation, that was one of the reasons for the stock drop. But here, they cannot point to the alleged wrongdoing having anything to do with the stock drop. That's loss causation. That's what they need to allege, and they can't do it. So instead, what they do is they try this new theory, the materialization of the risk theory, a theory that Georgia courts have never adopted in this context, nor has the 11th Circuit Court of Appeals, and they see securities cases all the time. That alone should be enough, but let's assume that Georgia had adopted the materialization of the risk theory. They don't plead it. Again, the risk has to be disclosed to the marketplace. If there was no revelation of the truth in the marketplace, you can't prove materialization of the risk. They have no risk that was uncovered that makes earlier statements untrue. All they have is, we didn't make earnings and the stock dropped. That is insufficient. I'm done. Any further questions, Your Honor?
I do not have any further questions. Thank you, Mr. Long.
Thank you. I'd like to reserve some time for rebuttal, if I may.
Absolutely.
Thank you.
All right, let's hear from plaintiff.
Good afternoon, Your Honor. Matthew Peller, Rolnick, Kramer, Siddiqui, LLP for the plaintiffs in the 4 actions. These 4 cases are brought against Mohawk, a leading flooring company, Jeffrey Lorberbaum, Mohawk CEO, and Frank Boykin, Mohawk CFO. The actions arise from a series of frauds committed by the defendants, lying to their investors about Mohawk's problems making luxury vinyl tile, a popular new type of flooring, hiding excess inventory, manipulating Mohawk's profit margins, falsely reporting sales of intentionally undelivered product. These interrelated frauds are supported by detailed allegations in the complaint. The defendants characterize these allegations as innuendo and conspiracy, but similar allegations have been sustained at the pleading stage in a federal class action in the Northern District of Georgia. Defendants say you need to kick the tires on the allegations. Well, the federal court kicked those tires and let the claims through a motion to dismiss to proceed to discovery. In addition, the DOJ and the SEC are both investigating Mohawk for the same misconduct that are alleged in the 4 complaints. The standard on this motion, Your Honor knows, so I'll be brief, but it's a rare case where a motion to dismiss should be granted, as the Court of Appeals said in Williams. The complaint should only be dismissed if the allegations foreclose relief, and no evidence could possibly be adduced within the framework of the complaint to support the relief sought. That's the Georgia Supreme Court in Anderson. In Brown, the Georgia Court of Appeals made clear that fraud, the truth and materiality of representations, and reasonable reliance are all, except in rare cases, issues for the jury. The bottom line is that defendants face an uphill battle to get the complaints dismissed on the pleadings here. And that, of course, makes sense, Your Honor. Having come forward with detailed allegations about defendants' pervasive fraud, including upheld by a federal court, plaintiffs are entitled to test those allegations through document discovery and depositions. Starting with Scienter, Your Honor, the complaints plead that Lorberbaum and Boykin had actual knowledge of the fraudulent schemes. The defendants mischaracterized the allegations by saying that they're only about an email here or an email there. But the complaints allege that Lorberbaum received daily production reports evidencing problems with the luxury vinyl tile LVT production. He attended a meeting in the summer of 2018 about those production problems. He guided tours of the LVT production line that the complaints allege were part and parcel of a scheme to deceive investors. With respect to the quarterly sales push, that is the scheme by which Mohawk would deliver product on Saturdays, knowing that customers could not receive the product, and then book those as sales, even though the product had never been delivered. Both Lorberbaum and Boykin received reports on those Saturdays detailing the purported deliveries. Those reports included how many orders were sent, the total number of pounds that were purportedly delivered. In some occasions, there were multiple reports on a single Saturday, showing just how hard Mohawk was trying to make its numbers by engaging in false sales. Sometimes people would respond on the email chain, noting how the false sales were able to help Mohawk hit its numbers and to come in at earnings. You can look to the Sorobon complaint in paragraph 88, for example, for those allegations. And it's difficult to see in the face of this how the defendants can claim that there's a lack of scienter here. We don't plead that Lorberbaum and Boykin should have known of the misconduct. The complaints go farther and plead that they actually knew and oversaw the misconduct and then falsely certified SEC filings about how there was no misconduct. Similar allegations in federal court were upheld as alleging scienter, and that's under a standard that's arguably stricter than the Georgia standard. The defendants fall back in the face of this damning allegations by saying that there's a theory of scienter is not required under Georgia law. And Lorberbaum and Boykin, as the CEO and CFO of a publicly traded company, obviously had a financial incentive to juice Mohawk's stock price to increase their own compensation. Moreover, the complaints allege that LVT, luxury vinyl tile, was becoming increasingly popular. It was growing 25% year over year in the marketplace. Mohawk had made a strategic decision to internally manufacture LVT, unlike some of its competitors that were outsourcing LVT from the Chinese manufacturing market. Production was delayed, though, and Mohawk was behind the 8 ball on LVT production. They were lagging their competitors, and they were facing falling behind in this increasingly important product area. That provides the motivation for why Mohawk engaged in this fraud. Moving on to justifiable reliance, Your Honor, and again, this applies to all of the plaintiffs except for Sorobon. The complaints, as Your Honor has noted, allege specific misstatements and omissions. The complaints allege that plaintiffs relied on those statements in purchasing Mohawk securities. The complaints allege that plaintiffs would not have purchased those securities or would not have paid the price that they paid had they known the truth. Nothing more is required, and Georgia law simply does not demand the pleading specifics that defendants argue. The Villa-Sonoma case, 349 Georgia App 672, is instructive. You just have to plead when misstatements were made, by whom, and quote, in what way they were acted upon. We've done that here. And the purpose of the pleading requirement in fraud is to give defendants fair notice of the claims. And we would submit that the complaints more than do that, Your Honor, here. We tell, as you pointed out, exactly what statements we're saying were relied upon and exactly the manner in which they were relied upon, i.e. by the plaintiffs purchasing Mohawk securities. The complaints were not required to plead anything more than they do to satisfy the justifiable reliance pleading standard under Georgia law. The defendants also claim that these are sophisticated investors and that they had to plead more about the due diligence that they did before purchasing Mohawk securities. Again, that's not the law in Georgia. GCA is directly on point here, Your Honor. 245 Georgia App at 464. There, the Court of Appeals reversed dismissal of a fraud claim, despite the fact that the plaintiff's only diligence was relying on his broker's statement that the stock that plaintiff purchased was, quote, the best company in the broker's portfolio. That was the only diligence required. And unlike here, the plaintiff in that case had signed a contract essentially disclaiming reliance on the broker. Even in those circumstances, the Court of Appeals reversed dismissal and said it was, could proceed to discovery on the issue in the case and did not hold as a matter of law that reasonable reliance was precluded. The notion that investors, even sophisticated investors, have to plead more than reliance on the extensive public statements of the company just doesn't make any sense, Your Honor, and would be bad policy. These were not offhand remarks that we're alleging here made by the defendants. These were statements made in SEC filings and to investors and analysts on earnings calls. And the extent to which these plaintiffs were required to do any additional diligence and what extent they were required to do it is an issue of fact for the jury. And that's the Scarborough case holds that and the Global Aerospace case holds that. Finally, any doubt that these defendants have pled justifiable reliance should go away because here there's a special relationship and under Georgia law that lessens the pleading burden. The defendants don't dispute that Boykin and Lorberbaum as corporate officers owed Mohawk shareholders a fiduciary duty, and that's upheld in the Lambeth case and the Thunderbolt case, both Georgia Court of Appeals cases, and that lessens any justifiable reliance pleading that the plaintiffs have to have here, Your Honor. Moving on to loss causation. The defendant's theory seems to be that as long as a fraud remains hidden, investors should not be able to bring fraud claims, even if the fraud causes a stock price decline. Obviously, this would incentivize companies to continue to hide their frauds and to engage in additional misconduct to prevent disclosures into the marketplace about fraud, and it's terrible public policy. Loss causation is properly reserved for the jury, except in rare cases. The Greenwald Court held that. Even under the federal standard, under Dura, U.S. Supreme Court decision interpreting the federal securities laws, at the motion to dismiss stage, the plaintiffs only have to give notice of relevant loss and a possible connection to the misrepresentations. That's 544 U.S. at 347. The plaintiffs have done that here. Loss causation, as Your Honor has already stated, is just proximate cause. Here we allege that as the market became aware of the consequences of defendants' schemes, the stock price decreased. The defendants' fraud concealed the risk that they would no longer be able to rely on the quarterly sales push and the production overruns to hit their earnings numbers. As that risk materialized, defendants were unable to pull into the current quarter a sufficiently large number of sales from the quarterly sales push to hit their earnings numbers. Price declined when they could not hit earnings numbers, and that was a direct and foreseeable result of the defendant's false and misleading statements. That's all pled. You could look at the Sorobon complaint, for example, at 135, 136. As to materialization of the risk, and we've explained this in the briefs, Your Honor, so I will be short on it, but in Holmes, the Georgia Supreme Court, 286 Georgia 636, recognized the materialization of the risk theory. It said that there are courts that have held that the truth could be revealed by the actual materialization of the concealed risk rather than a public disclosure that the risk exists. It just said that any theory of loss causation will have to identify when the materialization occurred and link it to a corresponding loss. And we've done that here, Your Honor. In particular, the complaints point to an analyst report calling into question whether Mohawk was, quote, stretching a little bit more each quarter to meet the numbers. And there are other allegations in the complaint that tie the revelation of Mohawk's earnings misses to the alleged fraud here, to the quarterly sales push, to the production problems, and to the production overruns. And you can look to Dow Systems, which we discussed in our brief. That's the Ninth Circuit case, a federal appeals court upholding a loss causation complaint on exactly the same theory, where an analyst report questioned whether the company was manufacturing earnings. In response, Your Honor, the defendants are basically raising fact issues. They ask, well, was this article like really talking about this particular wrongdoing, and how was the article perceived by the market? Those are issues for a jury. Those are issues for expert discovery, and should not preclude the plaintiffs here getting the discovery we need to move our claims forward into summary judgment and to trial. On the RICO claims, Your Honor, the Securities Act, there's no dispute that for RICO purposes, that is a timely predicate act. The 5-year RICO statute controls and not the 2-year Securities Act statute. And so we only need one more predicate act to get to the 2 predicate acts. Mail and wire fraud, as Your Honor noted, are alleged in the complaint. And the defendants here, they quibble. They say, oh, the complaints don't identify the use of the wires and the mail. But the complaints have extensive pleading about specific SEC filings and specific conference calls during which misstatements were made. And that's enough. A filing with the SEC, companies are putting that in through the internet, through a wire. As we put in our brief, use of the internet or telephones is use of the wires. And of course, also in our brief, the 11th Circuit has made clear in sustaining a criminal conviction, not even a civil case, that a routine use of the wires to accomplish that type of business is sufficient to support a conviction. So we didn't even have to plead here, although we did, that there were specific wires or mails. Just the fact that Mohawk usually files SEC reports by wire or usually holds conference calls with analysts over the phone is sufficient. And that's the Robertson case cited in our brief. The defendants on conspiracy, the allegations in the complaint are sufficient to infer a conspiratorial agreement between Lorberbaum and Boykin. They knew of the schemes alleged in the complaint. They falsely certified SEC reports, and they did nothing to stop the schemes. And they were involved in the schemes, including the quarterly sales push, where they got emails on Saturday when fake deliveries were being made about the progress of those fake deliveries. You could look at Evans and Cotman, both of which are cited in our brief, and that makes clear that given these allegations, the inference of a conspiracy is permitted on a motion to dismiss. The defendant's only response to those cases is that they concern cheating by teachers and administrators on school standardized testing and not corporate cheating. But, as should be pretty evident, cheating is cheating, and fraudulent schemes, no matter where they occur, have similar hallmarks of deception and chicanery. And that's exactly what we have pled here. On the timeliness of the Securities Act claims, Your Honor, and this only affects the Securities Act claims. So there's a 2-year statute of limitation for, what I call the Georgia Blue Sky claims. That's claims under the Georgia Securities Act. So when defendants talk about how the claims are so different, I'm not really sure what claims they're talking about. The only claim that is relevant for tolling here is Securities Act. And the Georgia Securities Act, as Your Honor has noted, is basically the same as the federal securities 10b-5 claims that are pled in the federal class action. What's the difference? The difference is one that Mr. Long harped on, which is reliance. But in terms of putting the defendants on notice of the allegedly wrongful conduct and the universe of plaintiffs who might bring suit for that conduct, the claims are identical. They both require material misstatements made with scienter to investors, causing a stock price decrease as the injury. The purpose of a statute of limitations is to place defendants on notice of potential claims and to prevent stale claims where evidence has been lost and witnesses' memories fade. Here, there can be no serious dispute that the defendants were put on notice by the federal class action of our Georgia Securities Act claims regarding the same misconduct and basically the same misstatements, if not exactly the same misstatements. And there's no dispute, I don't think, Your Honor, that the Georgia Securities Act claims are an analog of the federal securities claims raised in the federal class action. And so in these circumstances, it makes sense to permit class action tolling. And as Your Honor pointed out, the private truck council case that they rely on is distinguishable. And it's in our briefs, but Crown Cork, which is a federal case, Justice Powell of the Supreme Court, he explained why you would allow tolling for similar cases. He said it's appropriate so long as the second lawsuit raises claims that concern the same evidence, memories, and witnesses, 462 U.S. 355. And that's exactly what we have here.
Mr. Peller, I had a concern reading the private truck council case. It seemed to me that it could almost be read on the equitable tolling as dicta, since the court essentially ruled that the statute had already expired. The statute of limitations had already expired before the federal action was even instituted. So, it can be read as saying, even if equitable tolling applied, it wouldn't apply in this case. What I'm having trouble with is I don't see, and tell me if I've missed it somewhere in the papers or in the case law, where there's an affirmative adoption of equitable tolling by our courts. Any equitable tolling, not cross-jurisdictional or otherwise.
Yeah, I think Your Honor is right. Private truck council, there are cases that have read it to, if not adopt, to endorse the doctrine of what I'll call class action tolling. You can look at the Tool case. It's 2005, Westlaw 631-7417, and that was affirmed 280 Georgia App 372. That case described private truck council as allowing or at least endorsing an equitable tolling theory based on the filing of a class action complaint. And I believe the Georgia Supreme Court discusses, although not explicitly adopting it, but in the Shore case, SCHORR. But Your Honor is right that there is no case squarely saying, 100% bang on point that Georgia is adopting class action tolling.
Right, and as we get to cross-jurisdictional, it seems like the cases are all over the map, with some jurisdictions saying absolutely it applies, and others saying there's no way it should ever apply.
You're totally right, Your Honor. There is a split across the country in cross-jurisdictional tolling, and a few things on that, Your Honor. First of all, the interests that would be upheld in cross-jurisdictional tolling are the same interests that are upheld by the Georgia class action rules. So that is to say, protecting the claims of those that are encompassed in a putative class action before it is certified. And as the Georgia Supreme Court commented in Shore 287 Georgia at 572, the modern class action is designed to avoid rather than encouraging unnecessary filing of, repetitious papers and motions. And if cross-jurisdictional tolling is not recognized, what you would have is individual claimants being forced to file protective lawsuits in Georgia state court, where there's a federal class action, for example, pending, in order not to lose their claims if the class action is not successful and if they have to bring actions on their own. So, there's an efficiency concern, and we're not talking about individuals here who slept on their rights. The defendants, seem to imply that somehow the hedge funds, were dilatory here or dropped the ball, but their interests were protected by the federal class action that they were a part of. And, the tolling, cross-jurisdictional tolling, would serve to protect the rights of individuals who rely on a representative class action. And, we cite a New York Court of Appeals case that's pretty recent, I think last year, where the New York Court of Appeals adopted cross-jurisdictional tolling for some of the reasons that we've discussed.
So tell me, from a practical standpoint, what substantively, in terms of claims or recovery, does the Georgia Securities Act claim get you that that the common law fraud or the RICO claims cannot?
Your Honor, it's a good question. There might be additional measures of damages that are available, but I think Your Honor is right that the common law fraud and the RICO claims probably provide the latitude to award plaintiffs those types of damages.
All right.
So finally, on assignability, and again, this argument only concerns one plaintiff, the VRP, value recovery, and only the fraud claims. It won't eliminate VRP's entire case. The defendants argue that negligent misrepresentation sounds in fraud. We think, for the reasons explained in the papers and also just common sense, that that's wrong. The Supreme Court of Georgia and the Court of Appeals have held that negligent misrep sounds in negligence, which makes sense. That's in Baker and BDO. And then the injury for negligent misrep is economic loss. And the Supreme Court held that in Hardaway in 1997. And so it's not they're in negligent misrep, it sounds in negligence, and it's not a personal tort. So it's assignable under 44-12-24. And so the negligent misrep claims should survive. On the RICO claims, the defendants only argue that the predicate acts sound in fraud, which is true, Your Honor, but as the cases cited in our brief made clear, it's the pattern element of RICO that actually gives rise to the cause of action, and that's the DJ Powers case. So negligent misrep and RICO should survive, even if 44-12-24 applies to the fraud claim. The question on the fraud claim, Your Honor, involves the interplay between section 44-12-24 of the code and 911-17B, which is a choice of law rule, pointing the court to the law of the state of incorporation for a corporate entity. And here, VRP is a Delaware LLC, and so Delaware law should control whether the assignment of the fraud claim is valid, and the defendants do not dispute that the fraud claim can be assigned under Delaware law.
All right, I don't have any additional questions on that one, but I will acknowledge that I did not look at that unique issue from the value recapture cases, so I'm going to have to take a closer look at those cases and those arguments.
All right, thank you, Your Honor.
Okay. If you have nothing else, Mr. Peller, I will let Mr. Long have the last word.
Thank you.
Mr. Long, you're still muted.
Thank you, Your Honor. a few points. On Scienter, they allege that they've pled fraud, they pled Scienter intent, severe recklessness, because there were problems with the LVT product. Your Honor, what organization in the world doesn't have problems? There are a few at my law firm. I don't think there are any in your chambers, but there are some all over the place alleging that there were problems at Mohawk and that the CEO knew about it is like alleging the sky is blue. Of course it is. If you look at cases that we have cited, including the Find What case and the In Re Softimore case, you'll see that the disclosures have to be accurate. But that does not mean that by revealing one fact about a product, one must reveal all others too that might be interesting market-wise. Would the market have liked to have known about any problems at all? Perhaps, but they're not required by the law to disclose each and every fact about a product just because they talk about the product in their public disclosures. That is all they have for their intent. They don't allege that he was covering up anything when he got those reports. Any kind of wrongdoing. The special relationship argument that they raised, they're wrong about Mohawk. The law clearly says that the company does not owe the plaintiff a duty, and that's the Kniper v. Forest Group case, Northern District of Georgia, saying that under Georgia law, corporations owe their stockholders no fiduciary duties. So Mohawk does not have a special relationship to the plaintiffs. The wire fraud case, they fail to take into account the C-Space decision, which says that when you're alleging wire fraud, you can't just generally allege there were misstatements, okay? You can't just say that statements were made to the SEC and investors. You have to say that those statements, when they were made, that you relied on them, what they were. That's what says you've got to allege for mail and wire fraud. You can't just say statements were made. And so I think that claim fails. On the conspiracy, on the RICO conspiracy, they cite to the case saying that teachers were all doing bad things. The difference is that the teachers there were agreeing to do bad things. The principals told the teachers, hey, do this bad thing. The teachers said, okay, there's a conspiracy. There are no such allegations in the Mohawk case. And then the standing issue. It might be that Delaware law would let them bring this claim, but they brought these claims in Georgia and they asserted Georgia law, and Georgia law applies here, and value recapture does not have standing. That's it, Your Honor.
All right. Let me go through where I'm at and in the order in which the claims were argued in the motion to dismiss. Under the Georgia Securities Act claim, I believe that it is not entirely clear whether Georgia courts have expressly adopted the doctrine of equitable tolling. But it is certainly clear that Georgia courts have not adopted cross-jurisdictional equitable tolling, in which this is a circumstance. And there's going to be such an extension of Georgia law, it needs to come from up above my level. I'm not going to expand or add any new law that I don't see a solid foundation for in our precedents. So given my finding that equitable tolling does not apply, the Georgia Securities Act claim are barred as outside of the statute of limitations, so the motion is granted on that claim. As for common law fraud, I think the complaint is well pled. I think the complaint is specific. The complaint alleges numerous facts and circumstances that would allow a reasonable person, considering all the allegations in the complaint as true and as a whole, to find a claim for fraud in there. And all I have to do is examine it, everything in context, and say, is there no set of facts here that could sustain a fraud claim? And certainly there are more facts that could be pled. There are more connections that could be made. There are more details that could be provided. But there is certainly enough to find common law fraud in the complaint as pled. Now, a lot of what's been argued, I think, are fair arguments, as arguments of materiality and as to reliance and as to scienter, all very cogent arguments, very persuasive arguments, but in the end, those are issues of proof. And those issues of proof may be dispositive on a motion for summary judgment, but they simply cannot be addressed here at the pleading stage. So the motion to dismiss common law fraud claims is denied, except as to value recapture, that's reserved. I'm going to look at that case law a little bit more closely, and then I'll make a specific ruling as to value recapture's fraud claim. As to the RICO claim, I certainly don't believe there's any basis in the pleading for a theft claim as a predicate act, but there is certainly a basis for mail or wire fraud. Again, not specific as to dates, but or as to means of transmission, but certainly specific as to what statements were made. Certainly it can be adduced in discovery as to what channels some of those statements were made and whether that's enough to plead a predicate act of using the mail or wire or other electronic means. And certainly numerous instances of disseminations of information. I think there's certainly alleged enough predicate acts to support a Georgia RICO claim. Motion to dismiss is denied on the RICO claim. Likewise, it's expressly pled in the complaint on the conspiracy that there was a scheme, a common scheme and a common plan. Now that common scheme and plan hasn't been provided in complete detail, but again, I don't believe at this pleading stage they're required to allege things that they could not find out except in discovery. But certainly when you consider all the statements and in the context, there's enough to at least proceed to discovery on the conspiracy claim. So the motion is denied as to the conspiracy claim. On the negligent misrepresentation, I agree that there is not a claim for negligent misrepresentation against Mohawk Industries. And so the motion is granted only to that part, but it is denied as to Mr. Lauterbaum and Mr. Boykin. I think the law is clear that they do have a fiduciary duty to shareholders, and whether the extent of that duty and whether they breach that duty and whether and issues of causation are subject to discovery. So that motion is granted in part and denied in part as to the negligent misrepresentation claim. Have I addressed everything? Tell me if I'm missing something. All right, I'm hearing none, but if you think I haven't addressed something at this point, feel free to let me know, and you can let me or Mr. Townsend know afterwards. Mr. Peller, I'm going to ask if you would prepare proposed orders. I don't think you need to prepare proposed yet as to value recapture. I think we can, once I've reached a ruling on value recapture's fraud claim, I think we can adapt other proposed orders to handle the value recapture claims. But if you would, Mr. Peller, your side, draft proposed orders, get them to opposing counsel, see if y'all can agree as to form, and then send them on to Mr. Townsend. We'll go through them and we will enter an appropriate order.
Yes, Your Honor.
Any questions about the ruling or any other business that we need to handle here today?
Nothing from defendants, Your Honor. Thank you for your time.
Nothing for plaintiffs. Thank you, Your Honor.
All
Thank
right.
you.
Thank you all for being here, and I appreciate your time and efforts and your relative brevity on a very complicated set of facts and law. Everybody have a great weekend.
Thank you,
Thank
Your
you,
Honor.
Your Honor.
Thank you,
Thank
Judge
you.
Richardson.
You too, Your Honor.
Thank you. Thank you all.